a 9/0 earthquake the media barely noticed. While the country argued over headlines, the Supreme Court quietly handed gun owners the most important Second Amendment signal in a generation. There was no primetime press conference, no breathtaking news alert, no presidential tweet. Instead, on an otherwise ordinary June morning in 2025, the court released a short, unanimous opinion that ended a lawsuit most Americans had never heard of. Every justice, liberal, conservative, and swing signed the same crisp sentence. Firearms, such as the AR-15, are widely lawful and commonly owned by law-abiding citizens. Those 21 words are already ricocheting through courtrooms from San Diego to Boston because they did something no prior ruling had done in one breath. They constitutionalized the country's most popular rifle. In the next 20 minutes, we will walk through exactly how a case about Mexican cartels became the lever that may pry open assault weapon bans in 8 states, why lower court judges are suddenly quoting the line in footnotes, and what gun owners, gun control advocates, and neutral citizens should watch for next. If you want to understand what the law actually says, without slogans, without fundraising pitches, stay with me. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. Chapter 1. The Lawsuit That Should Have Been Boring. The story begins not with a homeowner in Wyoming, but with a foreign ministry in Mexico City. In 2022, the Mexican government sued Smith & Wesson, Glock, Colt, Ruger, Beretta, and others in federal district court in Massachusetts. The claim was exotic. Mexico argued that American gun companies knowingly designed, marketed, and distributed firearms in ways that made them almost certain to be trafficked south across the Rio Grande. No one alleged the manufacturers shipped guns illegally. Rather, Mexico said the firms created a public nuisance that enriched them while costing Mexican lives. The prayer for relief was eye-watering: $10 billion in damages and a court-ordered overhaul of industry distribution practices. Had the plaintiffs succeeded, the same theory could have been turned against car makers, social media platforms, or fast food chains whenever third parties misused lawful products. The district court dismissed the complaint under the Protection of Lawful Commerce in Arms Act, PLCAA, the 2005 federal statute that generally immunizes gun makers when criminals later misuse their products. The First Circuit affirmed. Mexico, backed by a cadre of U.S. gun control organizations, petitioned for certiorari. Most observers expected the court to deny review. After all, the lower court opinions were textbook applications of PLCAA. Instead, the justices heard 70 minutes of argument in February 2025, and then, without even requesting additional briefing, unanimously affirmed. The caption is Smith & Wesson Brands Inquietu v. Estados Unidos Mexicanos 601 U.S. 2025. On its face, the ruling simply preserved the status quo. Gun makers are not liable for downstream criminal misuse. But Justice Kagan's opinion contained a single, seemingly offhand, descriptive clause that is already reshaping constitutional litigation from coast to coast. Chapter 2. 21 words that moved a constitutional mountain. Here is the sentence, verbatim, from page 17 of the slip opinion. It is undisputed that firearms such as the AR-15 are widely lawful and commonly owned by law-abiding citizens for lawful purposes such as self-defense, hunting, and sport shooting. Read that again. The court did not merely say the AR-15 is not a machine gun or not inherently military. It stamped the rifle with 2 constitutional adjectives, widely lawful and commonly owned, and then tethered those adjectives to the classic trilogy of constitutionally protected uses: self-defense, hunting, and sport. Why does that matter? Because in District of Columbia versus Heller, 2008, the court warned that the Second Amendment protects arms in common use for lawful purposes. In Caetano versus Massachusetts, 2016, the court reiterated that the amendment extends to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And in New York State Rifle and on Pistolassen v. Bruen 2022, the court adopted a text history tradition test that freezes out balance of interests policy arguments. Once a firearm crosses the common use threshold, Bruen says a state must identify a distinctly similar historical prohibition from 1791 or 1868. If it cannot, the ban is unconstitutional. By declaring the AR-15 commonly owned, the 2025 opinion gave lower courts a Supreme Court-branded factual finding that triggers Bruen's protective umbrella. The sentence is dictum technically unnecessary to the PLCAA holding, yet it is the court's own dictum, adopted by 9 votes, and therefore entitled to more deference than a circuit court brawl. Within hours of release, attorneys in 10 separate pending assault weapon cases emailed the paragraph to their opposing counsel with the same subject line. Stipulate common use. Chapter 3. From Dictum to Doctrine. How lower courts are swallowing the sentence whole. The first ripple hit in late July 2025 when Judge William Shub, an 84-year-old Reagan appointee sitting by designation in the Eastern District of California, struck down the state's 1989 ban on so-called assault weapons. The case is Miller v. Bonta. The same litigation that had produced an earlier injunction later stayed by the Ninth Circuit. Judge Shub opened his 47-page opinion by quoting the 21-word sentence in italics, then spent the next 46 pages explaining why California could not identify a founding-era analog for a prohibition on common semi-automatic rifles that share core features with militia arms. 2 weeks later, a divided 3-judge panel of the Seventh Circuit stayed Illinois' Protect Illinois Communities Act, citing the same language. Dissenting Judge Diane Wood complained that the majority was elevating a throwaway line into a straitjacket, but the stay remained. In September, a federal judge in Connecticut reopened Shue v. Lamont, a dormant challenge to that state's 2013 ban, demanding that the state justify its statute in light of the Supreme Court's recent factual finding. Even the District of Columbia, which had won every assault weapon case since 2011, agreed to an expedited briefing schedule after plaintiffs plastered the 21-word sentence across page 1 of their renewed complaint. The city's Corporation General publicly told the D.C. Council that defending the ban is now 10 times more expensive and half as likely to survive. None of those cases has reached final judgment, but the momentum is unmistakable. The sentence has become a skeleton key that plaintiffs insert before states can even argue lethality. Chapter 4. Why common is more powerful than military style. Gun control advocates have spent 3 decades branding the AR-15 a weapon of war. The phrase polls well, but it suffers from a constitutional defect. The Second Amendment's core purpose is to protect civilians who might be called to war. In Heller, the court explicitly rejected the idea that the amendment protects only weapons in existence in the 18th century, and in Bruen, it mocked the notion that legislatures may ban firearms simply because they look dangerous. The 2025 sentence therefore flips the rhetorical board. By accepting as judicial fact that the AR-15 is commonly owned, the court moved the rifle from the dangerous and unusual bucket, which Heller allows states to ban, into the common use bucket, which Heller forbids states to ban. Numbers seal the lid. The National Shooting Sports Foundation estimates that 24.4 million semi-automatic sporting rifles, an industry euphemism for AR and AK platform guns, are in private hands today, more than double the 10.5 million Ford F-150 pickups on American roads. 1 in every 8 rifles sold in 2024 was an AR-15 variant. That ubiquity makes the rifle impossible to categorize as unusual, and the court's sentence makes it legally perilous to pretend otherwise. States are left arguing that 24 million is still a minority of the 393 million privately owned firearms in the country. Plaintiffs reply that 24 million is twice the number of Chevrolet Silverados, America's second best-selling vehicle, and no one thinks Silverados are unusual. Judges read the Supreme Court's adjective, commonly, and move on to the historical analog phase, where the state must produce a founding-era law that banned 15% of anything. So far, no state has. Chapter 5. The Historical Goose Egg. Why 1791 and 1868 are empty cupboards. Bruen demands a distinctly similar prohibition from either 1791, when the Second Amendment was ratified, or 1868, when the 14th Amendment made it binding on the states. The analogs must be well-established and representative, not outlier ordinances. cases. California tried first, citing 18th century English restrictions on guns of extraordinary length and post-Civil War Tennessee bans on pistols. Judge Shub found neither law comparable. The English statute regulated barrel length, not rate of fire, and the Tennessee ban was struck down in 1869 for violating the state constitution. Illinois next unearthed an 1881 municipal ordinance barring the carrying of muskets and rifles trimmed or shortened so as to be secreted upon the person. The Seventh Circuit panel replied that an AR-15 with a 16-inch barrel is neither trimmed nor concealable. Connecticut pointed to a 1920s ban on machine guns, but the district judge noted that the statute applied only to fully automatic weapons already illegal under federal law. Those whiffs are not for lack of trying. The George Washington University law professor who wrote Bruen's historical appendix searched 21 state archives and found 0 antebellum laws banning civilian rifles for looking too military. The court's 21-word sentence therefore lands in an evidentiary desert. Once a rifle is declared common, the historical cupboard is bare. Chapter 6. What happens to compliance rates when the law itself loses legitimacy? Before the Supreme Court spoke, owners of newly banned rifles faced a utilitarian calculus: comply and surrender property worth $2,000 or risk felony charges carrying 10-year prison terms. After the sentence, the same owners read newspapers announcing that the Supreme Court calls my rifle common. Psychological studies of legal obedience, from tax scholars and traffic researchers alike, show that perceived legitimacy is the single biggest predictor of voluntary compliance. When the Supreme Court itself brands a prohibition constitutionally suspect, non-compliance moves from defiance to self-protection. The numbers are already stark. New York's 2013 SAFE Act required registration of roughly 1 million existing assault weapons. 44,000 were registered, a compliance rate below 5%. California's 2016 bullet button expansion covered an estimated 200,000 rifles. 12,000 were registered, 6%. Illinois' 2023 ban covers at least 1.2 million firearms. After 18 months, only 65,000 applications have been submitted, a rate of 5.4%. Those figures long predate the 2025 sentence. Now imagine the curve when every social media feed carries headlines that SCOTUS says AR-15s are common. State officials privately concede that mass confiscation is politically impossible and logistically absurd. Police departments in downstate Illinois and upstate New York have publicly announced they will not initiate proactive enforcement while litigation proceeds. The court did not order states to repeal their bans, but by draining the moral authority behind them, it turned every owner into a potential plaintiff and every prosecutor into a potential defendant. Chapter 7. The bench's internal revolt. Why some judges are yelling at clouds. Not every jurist has surrendered gracefully. At an October hearing in the Northern District of Illinois, Judge Martha Pacold interrupted the state's attorney to ask, "Are you seriously arguing that a rifle owned by 24 million Americans is both dangerous and unusual?" When counsel replied that lethality, not ownership, should drive the analysis, Judge Pacold fired back, "Lethality is not the Bruen test, counsel. Common use is." A week later, in the District of Massachusetts, Judge Indira Talwani openly struggled during a status conference, at one point musing, perhaps the Supreme Court did not appreciate the downstream effect of its sentence. Plaintiff's counsel politely reminded her that, appreciated or not, the sentence is now the law of the land. The most dramatic moment came in a November oral argument in San Francisco, where Ninth Circuit Judge Ronald Gould described the AR-15 as a killing machine not remotely comparable to muskets. Judge Ryan Nelson shot back, quoting the 21-word sentence in full and adding, "When the Supreme Court calls a musket, we are bound. When it calls an AR-15 common, we are equally bound." These exchanges reveal a judiciary wrestling with a precedent it did not create and cannot easily distinguish. The court's sentence is short, but its gravitational pull is relentless. Chapter 8. The Domino Map, where the next shoes will drop. Second Amendment lawsuit litigation travels in coordinated waves. After Heller, suits hit Chicago and D.C. After McDonald, they spread to every state with major cities. After Bruen, they targeted may-issue licensing schemes. Post-sentence, the new frontier is feature-based rifle bans. Plaintiffs have already filed or threatened cases in Colorado, Delaware, Hawaii, Maryland, New Jersey, Rhode Island, and Washington. Each complaint quotes the 21-word sentence in the introduction. Each prayer for relief seeks both declaratory judgment and an injunction against enforcing any statute or regulation that prohibits the possession of firearms that the Supreme Court of the United States has declared commonly owned. The strategy is deliberate: secure a critical mass of district court wins, force the circuits to split, and tee up a Supreme Court showdown that could nationalize the holding. The court's conservative justices have repeatedly said they do not need to reach the assault weapon question because the Second Amendment's core is handgun possession in the home. The 2025 sentence gives them an off-ramp. They can invalidate bans without writing a new opinion simply by denying certiorari and letting the common use finding percolate. Meanwhile, the handful of states without rifle bans, Pennsylvania, Michigan, Minnesota, Wisconsin, are watching their neighbors' legal bills climb and quietly shelving new proposals. The dominoes are lining themselves up. Chapter 9. What gun owners should do and not do while the dice tumble. First, do not assume the sentence is a get-out-of-jail-free card. Bans are still on the books. Only licensed attorneys can give legal advice, and prosecutors in deep blue counties may still indict test cases. Second, preserve evidence of common ownership. Photographs of factory boxes, sales receipts, and range membership cards all help establish the lawful purpose prong if you become a plaintiff. Third, track the litigation calendar. Most challenges are set for decision between March and June 2026. Expect stays to be lifted and then reimposed as appeals climb. Fourth, if you live in a registration state, weigh risk tolerance carefully. Compliance rates may be low, but the first felony conviction will become a national news story and could chill the movement faster than any stay order. Finally, vote in state elections. The Supreme Court can declare a rifle common, but only legislatures can repeal the enabling statutes. A single flipped chamber in Illinois, Oregon, or Washington could spare the courts altogether. Chapter 10. What gun control advocates can still try, short of repeal. The sentence is 9 votes, but it is not a constitutional amendment. States retain broad power to regulate where, when, and how firearms are carried, to impose age limits, to mandate training, and to enhance sentences for criminal misuse. A state could, for example, criminalize possession of any semi-automatic rifle by a person convicted of violent misdemeanor stalking, provided the statute is rooted in historical laws disarming classes deemed dangerous. Red flag laws, if structured with clear pre-deprivation hearings, remain viable. Safe storage requirements survived Bruen and will survive the new sentence if they track 19th century fire inspection ordinances. The biggest remaining battlefield is magazine capacity. The court's sentence speaks only to the rifle, not to the detachable magazine, and the historical record contains several colonial limits on the number of charges a single weapon could hold. Expect states to pivot to 10-round caps, to outlaw tubular magazines on lever actions, and to press the sensitive places doctrine to declare entire urban cores off limits to long gun carry. Those fights will be ugly, but they are still fights, not foregone defeats. Chapter 11. The Long Game. Why one sentence may matter more than a dozen statutes. Constitutional law is a glacier, slow, cold, and unstoppable once it starts. The 21-word sentence did not merely nudge existing doctrine, it embedded a factual predicate that every future litigant can cite without reproving market share, sales data, or owner surveys. Over time, that kind of embedded fact becomes as immovable as separate is inherently unequal, or the internet is a forum for speech. Lower courts will quote it in footnotes. Law review articles will treat it as black letter, and eventually a future court will write, "as we long ago recognized." The sentence also reframes the cultural narrative. For 3 decades, the AR-15 lived in media purgatory, portrayed as a battlefield orphan foisted on civilians. Now, the highest court in the land has stamped it with the bureaucratic equivalent of social acceptance. Common. Once a product becomes common in constitutional jargon. Outright prohibition becomes as unthinkable as banning pickup trucks because they cause more pedestrian deaths than motorcycles. The glacier keeps moving even when no one is watching. Epilogue. Keep your eye on the docket, not the headlines. Cable producers prefer screaming panels. Fundraising emails prefer existential crisis. The real action is in dry PDFs uploaded to Pacer at 11:47 p.m. on a Tuesday. Track those filings, read the orders, and ignore anyone who tells you the Second Amendment is either dead or absolute. The court's 21-word sentence is neither the end of gun control law nor the dawn of constitutional utopia. It is simply a new baseline. If you want to ban a firearm that 24 million peaceful citizens already own, you had better find a founding-era law that did the same thing to 15% of anything. Until someone unearths that statute, the glacier grinds forward, one quiet opinion at a time. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.